Yes, Mr. Mann.
So, Lords, I will now address you on ground 2,
Yes.
which arises if I fail in ground 1. So the upper tribunal's remade decision is page 50. So sorry, it's page 82 of the bundle. So I'll take you straight to what in my respective submission are offending passages in the judgment. What this judge did was that he worked through the exceptions, looked at exception 1 first, said that it wasn't met, then looked at exception 2, said that it wasn't met, and then looked at very compelling circumstances. There are four complaints that I have about this judge's decision. The first complaint concerns the test of very significant obstacles to integration in exception 1. So may I take you respectfully to paragraph 33 of the judge's decision, page 92 of the bundle. Paragraph 33, the judge quotes from the judgment of this court in Kamara. This has received approval of the Supreme Court. This really is the test when considering whether there are very significant obstacles to integration in the country of return. The decision maker must conduct broad evaluative assessment and decide whether a person will have reasonable opportunity to be accepted and to build up a relationship within a reasonable period of time. And it's not confined to mere ability to find work and sustain life. The judge concludes that there are no very significant obstacles for the reasons set out at paragraphs 34 and 42. The conclusion is at 42 that in Zambia he'll be returning after 40 years, no connections, but the judge says that there are no very significant obstacles. What the judge has omitted altogether, in my respective submission, is the undisputed fact that this appellant was a victim of sexual abuse as a child and was assimilated into a cult. The fact that someone is a victim of sexual abuse is relevant to whether that person would face very significant obstacles to integration in the country of deportation. A person who is a victim of sexual abuse may find it difficult to trust other people, to build relationships, and that is something that may inhibit that person's ability to integrate. The short submission is that it was a relevant consideration, and a relevant consideration that was not taken into account by the
I can understand why, as a matter of generality, that submission might warrant consideration. But what evidence was there before the court to support it?
What was before the upper tribunal was the findings in the first year tribunal's decision that I took you to, where the finding being...
Right. Well, I mean, if the answer is it's based upon an inference from the findings that were made and preserved. Is that the point?
Yes. And that those findings were not taken into account in conducting the evaluative exercise that is required. So that is the first point. The second point concerns the way in which the judge approached the unduly harsh test in subsection 5. And that is directed to paragraph 52 of the judge's decision. The the judge there says that the appellant's deportation will have a significant emotional effect on the partner. The judge said that that won't be unduly harsh. Separating a couple who are in a close relationship is inevitably very upsetting for all concerned. And the point is that there's nothing undue about it on the facts of this case. The short submission is that the judge there, in my submission, is using the notional comparator. The baseline that the judge is using is of any couple, that any couple would find separation upsetting. And focusing on whether there was something more than that, on the judgment of the Supreme Court is an error of law. The third point concerns the way in which the judge approached the issue of rehabilitation. Now, we know, of course, from the Strasbourg case law that is cited in H.A. and H.A. itself, that rehabilitation is a relevant factor. If a person has not committed further offences following the offence for which he is being deported, if he has rehabilitated, if there is no risk of reoffending, if there is no risk of harm, then that addresses one aspect of the public interest, which is protection of public. And that is surely relevant. If you look at paragraph 62 of the judge's decision, the judge there notes that the appellant has undertaken charity work, and although he has offended, he has made contributions to the UK society. And then he says, well, that has the potential to diminish the public interest in deportation. Potential. And then there is a reference to UE, Nigeria, which in my submission has absolutely nothing to do with this. So UE is a case where this court made a point that if a person is making contributions to society, and if removing that person will have an adverse impact on the society, that is relevant. For example, if you have a nurse or a doctor who's providing services in a profession that is on the shortage occupation list, removing that person will affect not only that person but society, and that is relevant. But this is not that case. There is no conceivable impact on society. But there is, in my submission, a failure to recognize that rehabilitation is a matter that is relevant and that diminishes the public interest, or at least one aspect of public interest. So no proper recognition of that in my respective submission at paragraph 62. The final point is this, that there are two particular features of this case that merited very significant weight. They are very weighty factors. First, the appellant's length of residence is 40 plus years. And second, his traumatic childhood experiences. The judge, in my respectful submission, has not recognized that those were very weighty factors in assessing the question of proportionality.
Paragraph 64.
Yes. So this is where the judge says that I do consider it relevant that the appellant was subjected to such traumatic events as a young person, as a child. That is the reason why I made the submission that these two factors were very weighty factors. It's not enough for the judge to say that, well, I've considered it as relevant. there should have been a recognition that these are two very, very weighty factors in the assessment of proportionality. And perhaps it's fair, given that I'm making that point, to ask you to look at paragraph 59 as well, where the judge said that he had in mind that there was low risk of reoffending. Lord, for these four reasons, if you conclude that the first tier tribunal's decision was wrong in law, invite you to order a rehearing. Just one final point before I close my submissions that arose from the discussions that I had with my Malayan friend over lunch. I'm not making. You've heard me on law. I'm not making any radical submission. I'm not submitting that medium offenders or serious offenders are to be dealt with in the same way, or that the serious offender gets a better treatment than a medium offender. There is great public interest in deportation of medium offenders. There is a greater public interest in deportation of serious offenders. And if the fact-finding tribunal fails to recognize that, then I accept that that would be an error of law. So nothing that I said earlier this morning seeks to depart from that principle. I'm very grateful for your patience. Unless I can assist you any further, these are my submissions.
Grateful for yours, Mr. Malik. You've answered a lot of questions. Any?
No, thank you. No, thank you.
Thank you very much, Mr. Malik. Yes, Mr. Tabori.
I'd like to structure my oral submissions in this way. First, to address the law that has been addressed by my learned friend, then to turn to the tribunal's two decisions and the submissions on them, and then to address the additional submissions that we have put forward by way of respondent's notice, which it may be that my learned friend will address in reply. So as to the authorities, there are two main legal issues that seem to be coalescing before you. One is as to the meaning of over and above in 117C6, and the other is as to the significance of notional comparators. Both points that my friend, as you've heard, relies on heavily, depends on for to succeed. I'll start with the over and above. For that, can I take you back to NA Pakistan, which is your tab 7 authorities, and paragraph 37 on page 131. It may be helpful, Polly, whilst I clear my throat, if you read that paragraph to yourself.
Yes. Yes.
So the point in particular I wanted to rely on from this in the first line, it'll often be sensible first to see whether his case involves circumstances of the kind described in exceptions 1 and 2. That's relevant because this, contrary to what my friend says, relying on Yeltsin, this isn't a case about the upper tier ticking off the first tier for failing to carry out, to comply with a duty to start with the exceptions. That's not what the upper tier said. The first tier, as you've seen from the judgment, voluntarily, willfully started with them because as recommended effectively in NA Pakistan, it's often sensible to start with them. And the FTT did so for the reasons set out in this paragraph, namely that in order to gauge whether you are in the paragraph 6 category of over and above, helpful to start with the step up, if you like, on the ladder. And it follows that if, having taken that sensible approach, the first tier errs, vis-a-vis, in this case, the unduly harsh test, we'll come on to the specific error found, the upper tier is entitled to say so, and to say that in your chain of reasoning, i.e. via the exceptions en route to 6, you've got the exceptions wrong, then the step, if you like, that you've relied on to get to your number 6 step is misplaced. Hence the line about inadequate or legally inadequate reasoning in the upper tier's judgment, which we'll see in a second. The next relevant authority, again treading in my own friend's footsteps, is for this issue is Yalcin.
Do you accept?
Yes.
I think Mr. Malik's submission was that it is open to the first tier tribunal to go straight to very compelling circumstances.
Yes.
You do.
I do. Yes, absolutely. Yes.
Right.
But strictly speaking, my lord, and I did wonder whether a sort of follow-up point might be made about my own friend's stress on that principle, that proposition. But e.g., I thought it might have been said any error made in respect to the unduly harsh test is immaterial because, strictly speaking, the first tier needn't have gone there in the first place. But he didn't say that, and it wouldn't be immaterial because taking the approach of starting with the exceptions means that your reasoning in relation to 6 is contingent on it, follows from it. But in terms of a sort of narrow, formalistic, Yalcin style failure to look at them at all, absolutely we don't say that. So Yalcin, and the key paragraph is '57. It's on page 274. So NA Pakistan thus establishes the effect of the over and above requirement is that in a case where the very compelling circumstances on which a claimant relies under 6 include an exception specified circumstance, an exception overlap case, it's necessary that there be something substantially more than the minimum that would be necessary to qualify for the relevant exception under subsection 4 or 5. Pausing there, that's where we are here. This isn't one of those cases you may have encountered I've been in where you have the sort of articulate family life not captured by 4 and 5, such as family life not with a partner or a child. Sometimes it arises outside of those family relationships. This is an example that came to mind from my own experience. In that scenario, you're outside 4 and 5, and you'll have to rely on 6 and attain its threshold. But we're not in that scenario. We're in this first scenario at the beginning of this paragraph.
So there might be a case, say, of a foreign criminal in the over 4-year sentence category who, say, serves his sentence, comes out of prison, his wife or partner was primary carer for children, but now one of the children has Down syndrome and is, say, 19 years old, and B, he's the primary carer.
Yes, adult
So
child. Yes.
he's not within exception 4 or exception 5, but it might be thought, if it is legitimate to go straight to very compelling circumstances, that would be a rather good case.
Well, not necessarily, but maybe. Yes, certainly
Yes.
you'd be relying on 6. To say that much.
And
Or dependent on it, shall I say?
Not asking you to commit to a hypothetical, but the Home Office's reply might be various factual reasons. These are not very compelling circumstances, but you wouldn't be saying you simply don't get off the starting grid because you don't quite come within 4 or 5.
Yes, exactly. Yes. Otherwise, the statute would effectively have shut out anyone who engages Article 8 in its sort of Strasbourg sense, but not within these parameters.
But your previous point is that we needn't worry about
Yes.
this because it's not we're not in an other.
Yes, exactly.
We're in an exception-related plea.
Yes, exactly. I mean, you mentioned, my lord, a sort of medical treatment case somehow being an Article 8 question and yet not an Article 3.1.
Yeah.
Maybe that would be relevant here, but we're not in that territory anyway. But we are in the territory where the reliance is very much put on something which falls within these circumstances,
Yes.
namely, well, strictly speaking, not, because not qualifying partner or child, but there's certainly overlap.
So what does over and above mean? Mr. Malik says it doesn't mean in addition to.
Yes.
What does it mean?
Well, we'll see it in this paragraph, but I'm happy to address it head on.
Yes.
It's either over and above in a threshold sense of greater degree of interference so in this paragraph, Roger Sundhill refers to unduly harsh as a sort of epithet to describe how there might be an elevated version of one of the exceptions, the elevated degree. And another way in which is if there's something that falls outside it, and that taken with something that falls inside it reaches the higher threshold that my learned friend accepts in his final submission, applies in either case, whether it's a sort of combination situation or an elevated situation. In both scenarios, there is this elevated threshold.
It doesn't even have to be taken with, does it? Although commonly it will be.
Yes,
I
exactly.
mean, it could even be an issue which was not overlapping. I mean, as I understand it, over and above can mean either that the height is raised
Yes.
from unduly hard, or that the breadth is stretched, so
Yes.
that looking at it overall, you come to a conclusion that it would be these are compelling circumstances that go beyond.
It has to be over. It can't just be a wide range.
Yes,
You know,
I think that's right, my lord. I think it does have to be, because otherwise you have a situation where, because of the sort of nicheness of your Article 8 circumstances, because you don't fall within 4 and 5 through sheer luck of the
But
draw.
there's a difficulty in mixing metaphors between a geometric figure and a threshold and so forth.
Yes.
I mean, overall, what you're looking at in the end is you're looking at the substance of what you're seeing.
Absolutely.
something more, isn't it?
Yes, I mean, over and above, very much we say betokens height in terms of, and that must be the case, as my friend concedes at the end, because you're dealing with more serious offenders. Otherwise, as I was going to say, is that you would have individuals who have this sort of very strong relationship with their cousin, and because of the novelness of that, and they're falling outside of 4 and 5, that somehow gets them within 6, which can't be the case.
More substantial,
More substantial, however you
which
want.
encompasses things. It may encompass things within the exceptions, but it doesn't have to.
Absolutely.
And
Absolutely.
the Lord's example of an adult-dependent child so that capacity or whatever would be an example, perhaps. Thank you.
Yes, I mean, just looking at the provision itself on page 5 of the authorities, it expressly refers to exceptions 1 and 2. So almost in contrast to the next point of law I'll try and tackle, of notional comparator, here you're expressly enjoined as the tribunal to consider the comparator of the lower thresholds clearly set out in the exceptions 1 and 2. So that sort of relational quality means that there has to be this higher threshold, and it matters therefore to think about what we're talking about here if a tribunal entirely fails to refer to at times over and above, quite apart from apply, finding the something more, etc. So just to return to paragraph 57 on 274, the higher threshold may be reached either because the circumstance in question is present to a degree which is well beyond what would be sufficient to establish a bare case, or, as shown by the phrases I've italicised between 9 and 30, because it's complemented by other relevant circumstances, or a combination of both.
The italicised passages are from those paragraphs in the judgment in NA.
I'm grateful.
On the previous page. So when he's...
Yes, at 55.
I was a bit confused by that.
Yeah.
But that's what it means, I think. Yes, it is. It's he's in 55, he's quoting paragraphs 29 and 30 of Lord Justice Jackson's judgment.
Yes. So we have a clear, let's admit pretty clear analysis of what over and above means. You're not the first to consider it helpfully, and it's fairly clearly established. The complemented side of things, the something more, still must meet a higher threshold, and it can do so because you have, say, met one of the or both of the exceptions, but because that's not enough for you, because you're a serious offender, the presence of one or more factor not captured by the exceptions means that you are taken up to that higher threshold that must be implicit in 117C6. So that's as to...
The threshold of what? Harshness? Interference with your Article 8 rights, your child's, your partner's?
Yes, my lord, yes. Given that 6 refers to the exceptions, so that even if you are not caught by the exceptions because of how it's drafted to focus on specific scenarios, you're ultimately talking about the factors, the private life factors in 4, or the unduly harshness in 5. So it's over and above those thresholds. Keep using that phrase. So to go on to the other point of law that features significantly in this case today, the notional comparator. Here, can I take you to the first of the HA cases in the Court of Appeal, which is tab 9. Begins page 167 and the relevant paragraph is 157.
The Lord's judgment. Page?
Yes, sorry, whatever that is. Page 217. So starting about halfway down with Lord Carnworth KO, reference there to undue harshness to any child cannot have been intended to set up a notional comparator, if only because it's not possible to know what the circumstances of such a child might be. For some children, the deportation of a largely absent parent may be a matter of little or no real significance. For others, the deportation of a close caregiver where face-to-face contact cannot continue may be akin to bereavement. A decision that gives primary consideration to the best interests of the child will instead focus on the reality of that child's actual situation, and the decision maker will be more assisted by addressing relevant factors, as identified by Lord Justice Underhill, than by making generalised comparisons. Likewise, as explained in footnotes paragraph 48, the aphorism, "that is what deportation does," is an important truth. So I'd emphasise that bit, that it is an important truth. It's relevant, and the issue, as will become clear, is about focus. But my Lord's point about, as I've just read, focus on the reality. The full citation from Lord Justice Sedley and Lee makes this clear. Tragic consequences that this family, short-lived as it's been, will be broken up forever because of the appellant's bad behaviour. That is what deportation does. Sometimes the balance between its justification and its consequences falls the other way, but whether it does so is a question for the immigration judge. It can be seen that the aphorism frames the question, it does not provide the answer. What is not being said here, that you cannot touch on the implicit question of whether deportation entails inherent impacts. It's talking about that the focus shouldn't be on some sort of, to assist you in your task, don't invent a nominal, notional comparator. It frames the question, it doesn't provide the answer. You ultimately have to focus on what my Lord keeps referring to as the jury questions, ultimately. But can we also go to paragraph 23 in this same judgment?
This is back to Lord Justice Underhill.
Yes. And my apologies. At this point, we'd like to go on to the Supreme Court judgment, which is tab 10, and it's page 232. Yes, apologies.
Paragraph
So
23
it's
in the Supreme Court.
Paragraph 27 of Lord Hamlin's judgment on page 232 of your bundle, and in particular,
Lord Hamlin.
yes, Lord Hamlin and Lord Justice Underhill, but not in HA below, but rather in HARA.
No, that is
That is referring
HARA.
Okay, I could have found it in the document we were looking at then, but we can look at it here. And I think this points us to the answer to this point.
What he's doing there is Lord Hamlin quoting Lord Justice Underhill's explanation of Lord Carnworth.
Yes, absolutely.
The paragraph 23 is from Lord Carnworth.
Yes, so I'll just read from that paragraph, insert quote 44. In order to establish that the word unduly was not directed to the relative seriousness, it was necessary for Lord Carnworth to say what it was in fact directed. That is what he does in the first part of the paragraph. The effect of what he says is that unduly is directed to the degree of harshness required. Some level of harshness is to be regarded as acceptable or justifiable in the context of the public interest in the deportation of foreign criminals. And saying so doesn't involve introducing an artifice of the notional comparator.
Otherwise, judges wouldn't be able to put pen to paper without running, because of the use of ordinary language in them.
Yes, and then it would be a short skip from that to saying, well, you've implied it by essentially saying that it would not be unduly harsh. You essentially were saying, why wouldn't it be unduly harsh? It'd almost be impossible to rely on that provision. To go on, and what unduly does is to provide that exception 2 will only be applied where the harshness goes beyond that level. So goes beyond is your comparative element. So there is a comparison, there is a comparative element. It's just not with some sort of notional comparator. And then, just to carry on further, Lord Carnwath's focus. So again, that's the problem. That's where it goes wrong. Lord Carnwath's focus is not primarily again how to define the acceptable level of harshness. It's true that, which must be the case because the harshness may take different forms. It's true that he refers to a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of parents, but that cannot be read entirely literally. It's hard to see how one would define the level of harshness that would necessarily be suffered by any child. The underlying concept is clearly of an enhanced degree of harshness. And I would say that is all that has happened, all that was done by the upper tribunal. Before we go to the upper tribunal, staying within this judgment and coming out of the quote to Lord Hamblin's own judgment, so at 31 on page 233. Second sentence, it's correct that in paragraph 23 of his judgment, Lord Carnwath was recognising that the unduly harsh test involves a comparison. So that's perhaps the first point. It's not being said that that was wrong. So there is a comparison. But what the comparison made was between the level of harshness which is acceptable or justifiable in the context of the public interest in the deportation of foreign criminals. And to acknowledge that point, you almost have to acknowledge that there being a public interest in the deportation of foreign criminals, it doesn't make sense. It would be a sort of absurdity if that meant that any deportation was unduly harsh. You have to have regard to the fact that the whole premise of this is that some, if not the majority of deportations, will be not harsh. So that's, I hope that's helpful. That's all I would say on the question of on what the law says. Those are the two.
Paragraph 33 of Lord Hamlin.
Yes.
There's an echo of the notional comparator approach, but not being put forward as a test or touchstone.
Yes. Well, exactly. I mean, this is quite hard to almost to distinguish the two, really. I mean, the echo here is so there's
So, I mean, this is all covered in the submissions made to the Supreme Court, summarised in 29, isn't it? And that's really what Lord Hamlin is rejecting. The idea that this language used in that case, and you would say in this case by the upper tribunal, offends against the ban on a notional comparator.
Yes, I mean the Secretary of State was keen in these proceedings to sort of hang on to what had developed in a lot of the Court of Appeal cases. So if we go up above where I started, we see, so 24 helps to make my point. If you could go up to that, my lords, page 231, authorities. Justice Holroyd in PG Jamaica. It's now clear that a tribunal or court must focus not on the comparative seriousness of the offence or offences committed by the foreign criminal who faces deportation, but rather on whether the effects of his deportation would go beyond the degree of harshness which would necessarily be involved. So the point really, as I say, it's quite hard to distinguish, and we see that from the point about an echo. It's hard to see that it doesn't creep into a degree, at least as an echo. But where you go wrong is where you make that the aim of your exercise, and one can almost see where that trap, how that trap was reached, because, as I said before, in the context of the statutory provisions of paragraph 6, it's very much about a comparison. And so what's happened here is some of the judges following KO Nigeria have almost treated unduly harsh as entailing a similar relational question in relation to the notional comparator. But that doesn't mean that any reference at all to the implicit harshness, if you like, the non-elevated harshness in deportation generally, it represents an error of law. Whilst we're in HA in the Supreme Court, just to address another point made by my learned friend in relation to it, paragraph 52. About the weight to be given to the relevant factors falls within the margin of appreciation of the national authorities. My friend said that supported his points essentially about the caution to be applied to the first instance fact finder. What that's saying is about the margin to be afforded to the member states, which is what you see in 117C 4, 5 and 6. Ultimately the member states, the UK, setting per its discretion within its margin the thresholds at which it says the proportionality test is met for different seriousness of offence. That's what 52 is about. A brief point about 51, just because it's right there. My friend referred you to these factors. They are, of course, potentially relevant where engaged in the subparagraph 6 analysis, but they are not, as my friend seemed to be coming close to saying, a substitute for looking at the over and above question spelt out by the statute. Okay, that's all I think I'll say on the authorities.
Do you want to say anything about how he dealt with proportionality, or do you accept his contention about that?
It was actually being urged on me to, by those instructed to address that point. I chose not to in the interest of time because I don't think it's a particularly material point. I've sort of half made it now though by what I said about, is it 50? Yes, 52. Namely that the proportionality test, whilst of course my friend's taken you to all the various references to 6 being a proportionality assessment, is that the proportionality assessment that it is guidance to, because that's what 4, 5 and 6 are, they're statutory guidance ultimately, is loaded within, if you like, or framed within that statutory language such that you meet the proportionality test or you establish your deportation is disproportionate if you establish that statutory threshold. So it doesn't become a freewheeling outside of the statute, outside of the rules, old school Huang style, say, proportionality assessment, but it does represent a proportionality test of sorts, effectively,
yes,
as domesticated, if you like.
Not a great deal between you, I think.
No, I don't think it's a massively significant point.
I'm not sure Mr. Malik would like your word of sorts in that, but
well,
I won't open up a chasm that isn't there.
No, I mean, I only say of sorts is that it's very clearly not, say, a bank mellet number 2 proportionality test, is it? A sort of classic test. What it is saying that if you meet our specified threshold, exercising our margin of appreciation, then you'll have established it's disproportionate. And within that, you consider all relevant circumstances. Where relevant, that's the best interests. Where relevant, precariousness. See recent case of Arshad. But ultimately, it's not. It's a very particular proportionality test, shall we say? Tribunals aren't required to sort of reinvent the wheel, as it were. They begin with the test set down for them, and they err, as did this first tier, where they miss out a chunk, namely over and above.
Right, where do we go next?
To the first upper tier decision, please, my lord. The error of law decision. That's within your bundle, your hearing bundle at begins page 98 with the assessments and conclusions heading at 43, page 103 is a good place to start.
Are you going to go to the FTT later, or would you like to stick any more promulgated in it now?
I'm ultimately, given that we are considering an appeal from the upper tier, my consideration for first tier will be via the upper tier. You have the sort of introduction to what has been found, and it did at times sound almost as though my own friend was arguing the first tier case.
Well, that's got that is what he does under ground one, and he's entitled to, isn't he?
Well,
if he can show the upper tribunal had no basis to interfere, then made no error of law, then that's the end of it.
yes, so we start with he has to establish that the errors of law found by the upper tier weren't errors of law. So you have to start with what the errors of law found by the upper tier were.
Are we going to be looking at your respondent's notice?
Yes.
Along the
I
way.
was going to go to that at the end.
Yes,
I mean, maybe
I'm just wondering whether that's relevant to the question.
Yes.
Whether you go to the FTT first.
Well, the respondent's notice points in its additional submissions, as it says on in the heading, are additional reasons for upholding the upper tier's decision and effectively upholding both of those decisions. But neither descends into re-arguing the first instance case, as it were. I mean, it is a remaking. So I accept that in relation to decision number 2, it becomes more relevant to start afresh. But by that point, the first 2 decisions are out of the room.
Okay.
It's gone.
Yeah. Okay.
So whilst, of course, at that stage, you do have becomes more relevant to look at the sort of basics and some of the points I make in my respondent's notice, you're doing then with a clean canvas, and you don't need the first tier, save for the preserved findings, which the upper tier very clearly acknowledges. So unless there's a particular point, my lord, you'd like me to address, of course, I was going to start with the upper tier and look at what it says about the first tier.
All right.
So 43. We've referred in detail to the first tier's decision submissions made for us. Our determination of whether the first tier materially erred in the law does not need to refer extensively to the first decision. Common ground that because of the length of sentence, 6 years, we're talking about the very compelling circumstances over and above test. 45. First tier concluded that there were such very compelling circumstances. Respondents contends that he erred. 46. We're satisfied the first tier was aware of the need to establish very compelling circumstances. We're not, however, satisfied that he gave legally adequate reasons for concluding that there are very compelling circumstances such that the public interest does not require the appellant's deportation. Now, just a point here about my friend's submission that this wasn't a finding of misdirection, because what it says is legally adequate reasons. That is a finding of misdirection and of error of law. Firstly, because it's not adequate reasons in the sense of intelligible reasons. It's a ground of appeal to say that tribunal or in a judicial review decision maker failed to give adequate intelligible reasons. That has its own sort of body of case law. The legal adequacy here is the missing element of over and above, as the upper tribunal then sets out. But in this introductory paragraph 46, they add that there's an additional error of law found en route to that, namely the misdirection in relation to unduly harsh. As regards the latter, so starts with undue harshness, understandably, because of the sort of logical sequence between the two. It's to be remembered that the test for undue harshness is a high one, KO Nigeria, as also expressed in Hesham Ali, trite statement of principle. The learned friend relies on here the fact that the citation is KO Nigeria and the specific paragraphs as meaning that that the upper tier committed the notional comparator error that was found in or discussed in HA Iraq with reference to KO Nigeria, the misreading point about Lord Carnworth's judgment there. But that's simply not there. The fact that KO Nigeria is cited doesn't mean, and we can see from the judgment itself, that the upper tier is engaging in anything like a notional comparator exercise. The upper tribunal goes on. The first tier was entitled to his view of the evidence. So just pausing there, so to pick up and address as I go past my learned friend's point about this is ultimately comes down to a perversity challenge, insufficient caution or deference. The upper tier was very clear in relation to the evaluative and fact-finding aspects. The FTT was entitled to his view of the evidence in terms of accepting Alex's account of his feelings. And he was entitled, again, to take into account the evidence of conflict between him and his mother and the police involvement on an occasion. However, and this is the point where it was the misdirection comes in relation to unduly harsh. However, then to conclude at 40 that knowingly to subject a child to the prospect of anger and frustration is unduly harsh, fails to recognise and runs in opposition to the statutory regime within both the rules and section 117C. That regime necessarily contemplates the prospect of separation of a child from a parent who is to be deported, and the natural feelings that would engender in a child in many, in many, if not most, so there's no attempt to sort of crystallise a notional comparator. It's just acknowledging the implicit elements of a deportation scheme, as we've seen from the HA case at both levels. (48) It's true that the first tier had before him specific evidence of the frustration and anger that Alexander may experience. Again, a further sort of deference to the sort of prerogatives and advantages of the first tier, but we consider the first tier misdirected himself when concluding that the prospect of anger and frustration could meet the high threshold for undue harshness. That has to be correct, not just because anger and frustration, it might be thought, are themselves implicit and inherent in this deportation scheme and therefore not unduly harsh, for the elevated threshold for that we've seen from the authorities. But the mere prospect of it isn't a finding of it actually being the case. And then 49 moves on to talk about the other error, if you like, the one that pertains to the very compelling circumstances point. Furthermore, it's not at all clear from the first tier's decision that his finding of very compelling circumstances was anything other than a repetition of his view in relation to the unduly harsh effect on the appellant's son. Very compelling circumstances must necessarily involve something more. And that is the case, unless you're in the scenario where, well, it's always the case, effectively, because even if you're in the sort of breadth scenario, to use some of the terms we've been using, where you have a sort of novel factor that not caught by 4 and 5, it still needs to meet the higher threshold. So this is absolutely correct to say that something more is required. The very compelling circumstances finding in favour of the appellant is to be found in 47, but one sees its echo in 48. And then at 50, final sentence, he then referred to what he said at 39 in relation to that conflict with his mother, going on to conclude that on the particular circumstance of this case, such an outcome would be both unduly harsh and very compelling. So I will take you to that paragraph because it's only fair to the first tier. So that's 47, which you'll find on page 127, my lords. So that is the final sentence in that paragraph.
Linking them together.
Yes, so given we've been here before in circumstances described above, 39, which is talking about undue harshness. We've been here before in the circumstances described at paragraph 39. So that's almost expressly saying that I draw on the same factors. On the particular circumstance of this case, this outcome is one which I'm satisfied is both unduly harsh and very compelling. Now, of course, we know that you can succeed in relation to 6 by being unduly harsh, but that's not what's being found here. It's certainly not what's said. And there's certainly no reference to over and above that would show that the judge understood the law he was applying. And then it goes on to say, which is some clue, that paragraph 117C, without reference to the subparagraphs
Yes.
and their great difference. And to just save some time and sort of bring in the sort of additional points then, so the point I rely on is in relation to this 47, is that on the evidence before me, I cannot discount the possibility that a boy who is currently achieving well at school will, out of deep resentment and frustration, once again find himself in conflict, etc. That, I say, is below the standard.
Discount the possibility is not a finding.
It's not a finding, and it's certainly not, doesn't meet the statutory thresholds at 117C. So, namely, there would be, there are very compelling circumstances in the present tense, not mere possibility. Mere possibility isn't even clearly the Article 3 threshold for return expulsion cases of real risk.
You say that paragraph 47 focuses entirely on Alexander. It seems to me that at least it's most of it, if not all.
Yes, it does seem focused on Alexander, my lord, yeah.
It refers back to 39, given we've been here before in the circumstances described in 39. And 39 is all about him.
Yes.
Mr. Malik focused on line 3, the plural word findings plural, but he doesn't refer to anything specifically other than Alexander.
Yes, and which is why I stressed when we looked at Yeltsin in that first sentence, I don't know if you recall from the paragraph we looked at there. We'll go back to it just so it's clearer. Paragraph, the key paragraph of 57 on page 274. So the case where the very compelling circumstances relied on include an exception specified circumstance. So that was here in relation to Alexander. And so what was required per Yeltsin is that something substantially more than that minimum. So, as you say, the focus being on Alexander, in order to lawfully apply this test, there has to be the something more. So it's not just, this isn't just, the upper tier didn't just find infelicitous language where's the over and above. It's just that that is a massive clue to a misappreciation of what the test requires.
We look at the end of paragraph 52 of the Upper Tribunal, where you've just come from, page 104. Where the pure legal content of the error of law finding is in the last line, is it not? Failure to have regard to the essential distinction.
Absolutely. Yes.
And there are other conclusions reached to do with with whether the evidence could possibly achieve the correct standard.
Yes.
But here the Upper Tribunal is finding that the correct standard was not set.
Exactly. So two errors effectively found by the upper tier. One in relation to unduly harsh, one, but primarily in relation to, and secondly in relation to very compelling circumstances over and above. That one is a wholesale failure to appreciate and apply even the over and above element and all that it entails for Yalcid. The unduly harsh one is, as my Lord says, closer to a question of is the threshold met and appreciation of what that threshold entails.
Essentially, if you succeed in relation to subparagraph 6, then you don't need the Upper Tribunal's complaint about unduly harsh.
Yes. No, quite. Yes, to that extent, to borrow from a lot of my learned friends' emphasis this morning, it wasn't a necessary condition precedent, if you like, and it was. It's just that having gone there, the upper tier looked at it and found error. But strictly speaking, given that 6 was the actual applicable test, the upper tier's finding of error on 6 was sufficient for its error of law conclusion. I've addressed what my learned friend said about notional comparator. The bit about an evaluative judgment, I mean, neither of those points essentially involves any evaluation, as I've sought to emphasise. I mean, I haven't been through the whole judgment, but you subsequently see how there are even more references to the judge, first tier, having been entitled to consider this and all sorts of deference paid. At no point is there an attempt to sort of substitute a view of an evaluative view. I think that's all I need to say in relation to ground 1 and decision 1, unless you have any questions.
No, thank you.
No thanks.
Thank you. Ground 2.
Ground 2. So the first point, the 4 complaints, to take them in order. First was about 33 onwards regarding very significant obstacles. So just, if I could just quickly take you to that, it's on paragraph, page 92. And paragraph 33 onwards. And what I would say, just in relation to decision 2, is that my own friend's submission has very much followed the structure and content of his skeleton argument on decision 2.
Yes.
So I essentially repeat my submissions in response. But in case it helps to bring them out, in case you have questions and so on, I'll just go through them. So in relation to very significant obstacles, the appellant appellant's, my learned friend says, the upper tribunal failed to take into account the fact that the appellant was a victim of sexual abuse who was assimilated into a religious cult as a child in the UK. To which we say the upper tier had regard to this fact in its statement of the preserved findings, see paragraph 26 of the remade decision. Which is page 90. It's bullet 6 if you count down 1, 2, 3. Yes. For the circumstances in which the appellant came to the UK. And as my learned friend submits in relation to findings of the first tier tribunal, paragraph 30 of the skeleton, it's not credible that the earlier findings of fact were later forgotten. And it's further considered, this issue was further considered amongst factors considered in relation to the 117C6 test, see within the remade decision, paragraphs 63 and 64, page 96. And 67, page 97. Which doesn't refer to it expressly, but that is the overall assessment where the above stated factors are drawn together. So insofar as this point is simply you've left this out of account rather than trying to make any other sort of more developed point from it, it clearly was. So it's not clear how further regard to this factor would have altered the tribunal's conclusion that it was not satisfied that the appellant has established there would be very significant obstacles to his integration in Zambia in light of the evidence put before me, given the multiple reference to it, the correct self-direction for the test for integration, paragraphs 33 and 34 on page 92, as well as the other factors that were relevant to the integration question. See paragraphs 37, 40 to 42 of the remade decision, namely the ability to speak the language, to work hard despite his health issues, to make significant social connections with individuals of standing in the community, none of which are challenged. You know, it was a very considered evaluation of that question of 117C4C. The second complaint in relation to the remade decision is regarding the application of the unduly harsh test. In particular, the appellant challenges the upper tribunal's statement that at paragraph 52, page 94, that whilst I accept the appellant's removal will have a significant emotional effect on Miss C, I cannot see in the evidence that that effect would be unduly harsh. Separating a couple who are in a close relationship is inevitably very upsetting for all concerned.
Sorry, which paragraph?
Sorry, my lord, is that 52?
Oh, yes.
Yeah.
Right, yes.
And my friend levies the notional comparator criticism here, as you heard. But the statement impugned here doesn't involve or refer to a notional comparator in the sense of a defined standard applicable in all cases. The tribunal is performing the comparison inherent in the unduly harsh test, as defined by Lord Hamlin at 31, which we looked at, page 233 of your authorities. Namely, the unduly harsh test involves a comparison, so it is comparative. It's just that the comparison is with the level of harshness which is acceptable or justifiable in the context of the public interest in the deportation of foreign criminals, and the greater degree of harshness which is connoted by the requirement of unduly harsh.
You say unduly harsh, the positive of unduly harshness.
Yes.
Unduly harsh involves consideration of one set of circumstances with another.
Yes, namely a lesser form of harshness. A due harshness, which is quite the brutal converse, but
A lesser form of harshness.
lesser form, yeah. The next complaint is in relation to rehabilitation, that it's a relevant factor. Here, so the first point made by, wasn't made orally by my friend, was in relation to the attention to the reference to UE Nigeria. It's not repeated orally, but
He was.
it was. I'm so sorry. Well, again, then my friend cleaving very close to his skeleton, and the response to where it was put then is simply that was cited by the upper tier because it had arisen in the discussion in relation to the appellant's reliance on character evidence. You can see that at paragraph 12 of the remade decision, page 87. A lot of the first instance evidence was about sort of community involvement and so on. And then in terms of the rehabilitation evidence and the difference it would make, H.A. Iraq in Court of Appeal stage at 141, page 167 of your authorities.
Yes.
Apology, that's the first page. So the relevant paragraph is 141, as I say, and that's on 213. What Lord Justice Underhill said there is, the authorities seem to me to establish is that the fact that a potential deportee has shown positive evidence of rehabilitation and thus a reduced risk of reoffending cannot be excluded from the overall proportionality exercise. Authorities say so, and it might be right in principle in view of the holistic nature of that exercise. Where a tribunal is able to make an assessment of that the foreign criminal is unlikely to reoffend, it's a factor which can carry some weight in the balance when considering very compelling circumstances. The weight that it will bear will vary from case to case, but it will rarely be of great weight, bearing in mind that, as Lord Justice Moore-Bick says in Danso, the public interest in the deportation of criminals is not based only on the need to protect the public from further offending by the foreign criminal in question, but also on wider policy considerations of deterrence and public concern. I'd add that tribunals will properly be cautious about their ability to make findings on the risk of reoffending. So, rehabilitation can be relevant to risk of reoffending, but rarely be given great weight, given the wider policy considerations of deterrence and public concern. In this case, such weight as rehabilitation could bear was considered separately by the upper tribunal, which had regard to the preserved finding by the first tier that the appellant's risk of offending and of causing serious harm were low, and again when conducting the subparagraph 6 holistic assessment of relevant factors. See for the former, the preserved finding at paragraph 26, bullet 8 on page 90. fourth from the bottom on that page. And for the latter point, the holistic assessment, C59.
Yes.
Yes.
And the fourth point?
Yes. So the fourth point, I'm not really sure what it entails, really. I mean, certainly not presaged by the skeleton, as I understand it, but
I can't remember what it
I
was.
think it's
Two
about
features of the case which were
Missed.
long residence.
which merited very significant weight: the length of residence, 40 plus years, and his traumatic childhood experiences.
Yes.
Well, you say they're mentioned in the list.
Well, the traumatic experience is the first point, which I've addressed. So that's not a sort of separate one. In the first complaint, rather, in the list, which I've addressed. Both addressed considered and then factored in. As to
I
length
think the
of-
first case it's being deployed for very significant obstacles, and in the second case it's being deployed for compelling reasons. I think that's why it appears.
You say it's a weight issue, though, don't you?
Yes, ultimately it is, and it's worth probably bringing in here. This might be the correct point to bring it in, but as set out by in my skeleton, and as points made by my learned friend in relation to in seeking to attack the first decision, I make the same points in relation to your approach to the second decision, namely see paragraph 72 of H.A. Iraq in the Supreme Court, page 242 to 243. Where a relevant, so perhaps particular 72.2, where a relevant point is not expressly mentioned by the tribunal, court should be slow to infer it's not been taken into account. So, well, all that leaves, but lest I forget, are my the additional submissions, some of whom which have been touched on by the as I've gone through already.
Give me the page of those.
They are within, I should find them in my skeleton at page 12, paragraph 61 onwards. The first point I mentioned, my lords have already brought out in considering the case, namely the clear error at paragraph 44 of the first tier's judgment, page 126. These are not victimless crimes. I do not find very compelling circumstances in those events, which is a complete misappreciation of what that, I mean, it's treating, having shed the over and above element of that key legal phrase, very compelling circumstances is just floating around as a descriptor to be used in this instance in relation to crimes. Second point is the significance of a almost complete failure by the first tier to direct itself in accordance with the case law on section 117C6. The only authority considered, again, something that you've already brought out in your questions, my friend, was Uganda, a medium offender case. And the significance of that, of course, my friend took you notably, understandably, to just saying that in Yalcin, strictly speaking, absence of reference to case law doesn't mount to an error of law. Why I'm relying on it is I submit that it prevents the taking of what you might call a benevolent approach to, along the lines of those cautionary statements in H.A. Iraq at 72 from Lord Hamlin, or in Ullah. You can't infer and treat the tribunal as knowing what it's doing, having failed to set out even the statutory framework, let alone the relevant cases. I think it was pointed out in respect to the chronology that these cases had been decided by them. The next point is one I've mentioned already. It's about the standard of likelihood and the standard of proof. And in particular, the tribunal saying at 47 on page 127, in the key balancing exercise section of its judgment, on the evidence before me, I cannot discount the possibility that a boy who is, etc. So I made that point already. Submit that is a freestanding error of law in the application of a test which requires that there are very compelling circumstances. And it's sort of was made worse by the fact that at 48, the tribunal then referred back to, quote, "My findings, his son cannot reasonably and safely settle with him in Zambia, and the likely consequences for his son." But the tribunal hadn't made findings. It merely talked about a possibility. The next point is, which also amounting to a reason for finding misapplication of section 117C6, which was the tribunal's conclusion, is in relation to the first tier's paragraph 43, page 126, where it said, "I now set out the matters relied upon by the respondent in her public interest argument." And then at 44, it began a list of those matters. It said, "First, I deal with the offence itself." But the first tier didn't add any further items in that list.
You're really, you're just, at the moment, you're reading from your skeleton argument, aren't you? I mean, we have...
Yes, yes. Well, I'm hoping through doing so to take you to bits of the judgment, but absolutely.
Well, and
and some I'm leaving out as well.
Your respondent's notice is partly page 15, greatest hits compilation of submissions you paid already.
Yes, I'm trying to skip those and focus on the additional.
You're now on to secondly and thirdly. Can I just take a minute to read through thirdly, and you take a minute as well, and then see if there's anything you hadn't so far mentioned. Yes, I mean on the length of sentence point, to some extent, how long is a piece of string? Of course, a 6-year sentence is higher than a 4-year sentence. On the other hand, of course, there are even worse cases, just short of life imprisonment, or so on. But you say what? it's a relatively minor factor in the overall approach dictated by 117C6, and in any case at one point in the judgment the FTT judge appeared to say that the fact that the offences were acquisitive rather than anything else was not very compelling circumstances.
Yes.
Right, I think we've got those points.
Yes, I mean, if it helps, just on that point, we don't say that so long as you cross the threshold, that's all that's relevant. 1172 almost expressly enjoins the tribunal to consider the actual seriousness of the offence, and there are judgments on the sort of nature of it. Where there are problems in relation to sentence is don't arise here. I mean, you get issues where it's necessary because there's credit for a guilty plea to look at what it would have been as the full measure of the seriousness, but that doesn't arise here. But I certainly do say, as you see from the additional submissions, that these points about being at the lower end of the continuum really do sort of have regard to a sort of notional comparator or a notional continuum, which were unsustainable. We say, and
could I divert you to what might be a more substantial point? In paragraph 61 and 62, which is your first respondent's notice argument.
yes,
Would it be right to read that in this way? That your primary submission, as I understand it, is that the first tier tribunal did make an error of law by misdirection.
yes.
And is the first argument that you make in paragraph 62, as it were, there to bolster that by saying that if we were to find that the upper tribunal had not framed it in that way, then nevertheless the first tier tribunal did misdirect itself in the manner suggested?
I'm not sure I follow, Lord. Strictly speaking, and the reason why I skipped over 62A is that it is very much the points that we make that the
I know,
tribunal
but
did
Mr.
actually.
Malik doesn't agree with you. Mr. Malik says that this was a perversity
Yes.
appeal that succeeded in the upper tribunal, and we have to decide whether we agree with that or not.
Yes.
But let's suppose we were persuaded by Mr. Malik that the upper tribunal had allowed the appeal on perversity grounds
Yes.
and not on misdirection grounds. Your argument would then come into play, namely that in fact there was a misdirection by equating the two
I see what you mean.
tests.
Yes.
Right, so it's to deal with, I mean, it seems to me that argument, which is by far the most important of your respondents' notice points, as it seems
Yes.
to me,
No, that
is there in case we were to accept Mr. Malik's account of what had happened in the upper tier tribunal.
it certainly
tribunal.
serves that function, my
Yes.
lord. I can't.
It's
recall
not
whether I
a
intended that.
concession that the upper tribunal did in fact decide the
No,
case in that way.
absolutely not. Yes.
Okay, that's what I was wanting to ask you.
I'm very grateful, Lord. That is helpful, because by route of the respondent's notice, we effectively are then saying that even if you're against us as to what the upper tier did, nonetheless we say it could also have found it to have been misdirection. Yes, absolutely. Unless I can help you any further, Lord.
No, thank you.
No, thanks.
Thank you very much, Mr. Malik.
Lords, three very short points on law, and then three very short points on the facts in reply. Lord, first, whatever construction my lords will give to the phrase very compelling circumstances over and above exceptions 1 and 2 will apply not only to serious offenders but also to medium offenders. I mentioned that in my oral in my opening submissions, I referred to a drafting error in the legislation. Can I just show you the authority that deals with that drafting error and why I make that submission? So if you go to NA Pakistan, which is tab 7.
I'm sorry, reference again?
So NA Pakistan,
NA, thank you.
tab 7.
Okay.
And if you look at paragraph 24, this is the point that my Lord Justice Bean made when I was making my submissions, that accepting my submissions would effectively mean that a serious offender is in a better position than a medium offender. And Lord Justice Jackson found that to be a rather curious feature of section 117C. And he then says that would be a bizarre outcome, bizarre and extreme outcome. And he then says at 25 that there is a drafting error. And then on the Secretary of State's invitation, he corrects that drafting error. So what it means, my lords, is that subsection 6 is available both to medium offenders and to serious offender. Well, this is something that the Supreme Court agreed with or proceeded on that basis in HA Iraq. If you need reference to the paragraph number, it is paragraph 4 of HA Iraq, tab 10, page 226. Now that then links to the second point.
Sorry, just a minute.
Yes. Tab 10, paragraph 4. There is another authority which you don't have in the bundle, where the Supreme Court probed into the soundness of Secretary of State's invitation to the court to say that there is a drafting error, and it was.
What do you mean by soundness? Accuracy, or whether it was legally permissible to?
Soundness, whether it was a good idea for the executive who sort of tabled the legislation to say that
constitutionally appropriate.
Yes.
The legislation to be amended by one element of the
yes
one power, the separation of powers, at the invitation of a second.
yes.
So usurping the role of the third.
Yeah. Yes, the point Lord Reid was making in a case called SC Jamaica, Miller and Friend and both were in that case on the same side, where Lord Reid was probing into that question, as it is the Secretary of State who tabled this legislation, approved by Parliament, and now the Secretary of State is saying that, well, there is a drafting error, and asking the court to correct it. But even in that case, the Supreme Court proceeded on the basis that, well, that is the position.
Lord Reid didn't demur from what Lord Hamlin and the other. Well, indeed, in fact, as he agreed with Lord Hamlin.
Yes, so there's no issue now that there is a drafting error.
Okay.
So whatever my lords will say about subsection 6 on its construction will apply to both medium and serious offenders. Now this then links to my second point as to what that phrase actually means, and my lords have probed into that with care this morning and this afternoon. My Lord Justice Baker said that does it mean over and above or beyond, whether it means in addition to, whether it means, well, more substantial than the exceptions, height and breadth are the phrases that are used. Now, in my respectful submission, it would not be appropriate, and I say this with the greatest respect, it would not be appropriate for this court in this appeal to seek to construe that phrase in any of those ways. But this court,
Impermissible gloss.
yes. So now, yes, this isn't. Yeah, that would be an impermissible gloss, a gloss that the Supreme Court and previous constitutions of this court decided not to give to the provision. What this court should do, in my respective submission, is adopt what Lord Hamblen said about the test at paragraph 5 and just leave it there. There was a good reason why Lord Hamblen said what he said at paragraph 5 and decided not to give a gloss, because that gloss will then have to apply to both serious offenders and medium offenders. So the test is simply this, nothing more than that, nothing less than this. Very compelling circumstances test, very compelling circumstances over and above the two exceptions, is a full proportionality assessment to be carried out, weighing the interference with the rights of potential deportee and his family, the private and family life under Article 8 of the Convention against the public interest in his deportation. That is what that phrase means.
Well, over and above.
No, the entire phrase, exceptional circumstances, very compelling circumstances over and above exceptions 1 and 2. That phrase means this, what Lord Justice Hamblen said at paragraph 5.
I'm sorry, I'm not reading that paragraph as a definition of the very compelling circumstances test. It's descriptive of the process. It's not definitional. Sure.
Well, very compelling circumstances test requires this.
It certainly requires it to happen. Yes, it's not a redefinition.
No, but this is what it entails, and then this is what he then repeats subsequently in the judgment as well. Paragraph 20. Yes, paragraph 47b. In my respective submission.
Sorry, 47 of Lord Hamblen.
Yes, 47 of Lord Hamblen, where he refers to what Lord Sandhill said in HA Iraq 47b. It requires is full proportionality assessment. So I invite you to proceed on that basis, that the test requires a full proportionality assessment balancing two interests. And on that basis, I invite you to determine this appeal. But final point on law.
Can I just, before you do that, would Lord Justice Underhill use the phrase "something more"? Having quoted Lord Hamblen's paragraph, you referred to Lord Hamblen's. He quoted paragraph 47 of
Yes.
Lord Hamblen at paragraph 53 of Yalchin,
Yes.
and then looked at Lord Justice Jackson and the passage which Lord Hamblen had approved in NA Pakistan,
Yes.
and then in paragraph 57
That's it. Yes.
in the passage we've looked at.
Yes.
And he says, I won't describe it as a gloss, but the phrase he used, the paraphrase he used was something more.
Lord, I'm just looking at the middle of paragraph 57, and I took you to these four sentences where the highest threshold may be reached either and then or both.
Whichever kind, it's something more.
Yeah. So it can be something more beyond, or something different that complements or combination of both. Now, the reason why they left it there rather than saying that, well, this is sort of substantially more, is that this is something that is available also to medium offenders. And there's no sort of universal, in my respective submission, rule that one can adopt that then applies to both serious and medium offenders. So that is the reason the courts left it where they left it, that this is a full proportionality assessment. You look at all the circumstances, and it can be features falling within the exceptions for particularly compelling kind, something more. It can be something different, or it can be a combination of both. But what it ultimately requires is a full proportionality assessment. So my final point on law concerns the task of this court. Absolutely no doubt in my respective submission that it would be appropriate for my lords to simply focus on the first year tribunal's decision. The question as to whether the first year tribunal erred in law is a question for this court, and therefore whatever the upper tribunal said makes no difference. The question isn't whether the upper tribunal was entitled to interfere with the first year tribunal's decision. Yalchin paragraph 52 makes that absolutely clear. There is a recent judgment by Lord Justice Singh, you don't have in the bundle, that it makes the point that this is what Yalchin says, that when you focus on the first year tribunal's decision rather than looking at the upper tribunal's decision. If you need, I have a reference to that judgment.
No, it's all right. It's pretty well trodden ground. I mean, Lord Justice Underhill, like me, has spent much of his working life on employment appeals. It's the same rule that you focus principally on the original tribunal decision to see whether it made an error of law.
Yes.
And if it didn't make an error of law, then the employment appeal tribunal, or in the immigration jurisdiction, the upper tribunal, is really neither here nor there. But if you can show an error of law, then that's what the upper tribunal said it is quite important.
Yes, very grateful. Lord, do you need a reference to the authority that I mentioned, or just shall I leave it off? Very grateful. Now, three very short points on the facts. The primary submission that my learned friend made, and if I've understood the questions that Lords were putting to my learned friend correctly, this really is a matter that is troubling my Lords, which is that the first year tribunal misdirected itself as to the very compelling circumstances test. The first year tribunal said that my task is to decide whether there are very compelling circumstances. My learned friend says that the words over and above exceptions 1 and 2 are omitted. Lord Justice Peter Jackson said that, well, that is a more substantial point which I respectfully agree with. So there are three reasons I respectfully seek to put forward, inviting you to reject that submission. First is that this is a specialist tribunal and is expected to be aware of the law. Just as failure to refer to a case law is not an error of law, failure to set out precise statutory language in a decision is not an error of law. Second, the court can conclude, in my respective submission, with confidence that the judge had the correct test in mind. This is because he referred expressly on multiple occasions to section 117C of the 2002 Act in the decision. It's not that the judge made a random reference to very compelling circumstances. Before he said that, he referred expressly at paragraph 24 to the statute, and then refers again to the statute at the end of the decision at paragraph 47. That, in my respective submission, indicates that he knows that very compelling circumstances mean very compelling circumstances over and above the two exceptions. Third and final point is that if you accept the submission on law that I've made, that very compelling circumstances over and above two exceptions mean what Lord Hamblen said at paragraph 5, namely that it requires a balancing exercise, then there is no error in the judge's decision. I ask you respectfully because the judge said that categorically, that he was conducting a balancing exercise at 3 different paragraphs in the decision. Firstly, you have paragraph 26 of the judge's decision, to which I took you towards page 123 of the bundle. This is where judge said that I must nevertheless consider whether there are compelling circumstances such that he should not be deported. Not very different from what Lord Hamblen was saying in H. Iraq at paragraph 5. Then paragraph 33, he says that, well, my job is to balance conflicting interests of the respondent and the appellant. This is what Lord Hamblen was saying in H. Iraq. Then paragraph 47, he starts that paragraph by saying that he is conducting a balancing exercise. And finally, paragraph 49, he says that, well, the outcome of the balancing exercise is that the decision is not proportionate. So in substance, the judge did what the Supreme Court required him to do, namely to conduct a full balancing exercise. There is therefore no misdirection in law. Second point that concerns unduly harsh test. When my learned friend was making his submissions, my Lord Justice Bean said that paragraph 40 of the judge's decision is all about the child. And
Or
this
47.
Yes, my apologies, yes. 47 is all about the child and nothing else. My lords will recall that when I made my submissions, I placed particular emphasis to the word findings above. That I submitted include all findings that are made above. And if you go back to page 126 and see paragraph 42, you'll see that sort of reinforces the submission that I've made. At 42, the judge is saying the factors set out at length above, not only the factor about child, but all factors that are set out above, go in one side of the balance, namely in the appellant's favor. Now, those factors, as I sought to explain in my opening submissions, include a number of different matters, eight matters that I counted. It's not simply welfare of the child or unduly harsh. The appellant's 40 years residence, entry as a child, sexual abuse, previous relationship, current relationship, rehabilitation, low risk of reoffending, nature of the offences, etc. So in my respectful submission, it is wrong to proceed on the basis that this judge allowed the appeal simply because of the impact of deportation on the child. The judge looked at all these matters and then made his decision. Now, this also, in my respectful submission, addresses a point that my Lord Justice Peter Jackson made when my learned friend was making his submissions. So my learned friend took you to the upper tribunal's decision and showed you paragraphs 49 and 52, and it's paragraph 52 that my Lord Justice Peter Jackson picked. So this is where the upper tribunal said that something more is needed 49, it is not clear from the first year tribunal's decision that his finding of very compelling circumstances was anything other than repudiation of his views in relation to unduly harsh effect. Something more is needed. Paragraph 52, well, it's not simply about child, something more is needed. In addition to that. Now, keep all legal arguments to one side. There is plainly something more in the first year tribunal's decision, not simply the child, the list of factors that I itemized. It is clear in my speculative submission that first year tribunal weighed all those factors in balance before making a decision. The final point, my lords, concerns the correctness of the finding at paragraph 40. The finding at paragraph 40 is that the effect of the deportation on the child would be unduly harsh. That finding, Miller and Friends says, is wrong in law. And the upper tribunal said that that finding is wrong in law because there was either a misdirection or the reasons are not adequate. Now that, in my respective submission, is premised on reading paragraph 40 in isolation. The submission or the upper tribunal's analysis assumed that the entirety of the reasoning as to why the consequences would be unduly harsh are in paragraph 40.
For Alexander.
Yes.
Yes.
But they are not. In my respective submission, what you have at paragraph 40 is the conclusion of the analysis that you have at paragraphs 37, 38, 39, and
You say it brings in all the findings, the 8 findings that you identified, or how you categorise them.
No. Yeah. So
They're all brought in.
Yes. No. I'm simply, for the purpose of this point, focusing on the child,
Okay,
the unduly
alright,
harsh finding that
Yes.
the upper tribunal said is not justified.
Yeah, the upper tribunal was having regard to aspects of his welfare that went beyond how he would feel. The first tier tribunal was,
Yes.
Yes.
was having regard, one can see that from the sequence of
Yes.
paragraphs.
Yes. So it
It
is not
37 to 40 have to be taken as a whole.
Yes.
that is a submission. So it's not the case in my submission that the judge is saying that, well, the child will get angry and frustrated, and that is unduly harsh. In my respective submission, paragraphs 37 to 40, when you look at those paragraphs, you'll see that the judge made five different points about child. The first is that this is a disturbed child, a child who's already disturbed because of what has happened in his life. Second, the father is working hard to stabilize child's emotional development at this important time. Second point. The third point is that the child's relationship with the mother has deteriorated significantly. There was, what the judge says, an acute confrontation resulting in police being called. Fourth, deportation of the appellant will fracture, the judge said, the child's relationship with either the mother or the father. If he goes to Zambia with the father, the relationship with mother will come to an end. If he stays, the relationship with the father will come to an end. And then fifthly, deportation will increase his anger and frustration. The question for my lords is whether these 5 factors are capable of giving rise to a finding that deportation would be unduly harsh. In my submission, these 5 findings were open to the first year tribunal. And if these 5 findings were open to the first year tribunal, the conclusion that deportation would be unduly harsh is not an irrational or perverse conclusion. It is a conclusion that one can disagree with. One may feel that it's a generous conclusion, but it is one that was open to the judge on the evidence. And therefore, there is no misdirection in relation to the unduly harsh test. I mean, there's no paragraph in the decision, for example, which says that unduly harsh test means X, and X is wrong. It actually means Y. The reasons are adequate, and the ultimate conclusion is not perverse. I'm very grateful. These are my submissions in reply.
Thank you very much, Mr. Malik. We're grateful to you both. We will reserve judgment. We will send out the draft judgment in the usual way. Counsel know what I'm going to say next, but I still have to say it in every case. The draft judgment is sent out not for the purpose of the allowing the appeal to be re-argued, but simply for the correction of typos and other obvious factual errors like wrong dates and so forth. Otherwise, that is the judgment which we hand down. We invite the parties to agree any consequential orders. The outcome, the result, may be communicated to the parties, that is the appellant himself and those in the Home Office who have to know in order to be able to take instructions about the judgment, but otherwise it's confidential until the judgment is formally handed down in the sense of being posted on the National Archive website. Thank you very much for your assistance.